Hello, my name is Ian Larkins of Radius Law and welcome to our commercial bulletin in association with LexisNexis. Force majeure clauses typically relieve parties from contractual obligations that they are unable to meet due to events outside of their control. The clauses often also allow for termination. The High Court has, however, given organisations a warning to not leap to using force majeure clause to terminate a contract for a performance delay. Unless the delay would materially undermine the contract, it is unlikely to provide a reason to terminate it. It's generally considered that you can restrict a business partner from competing with you after your relationship ends, provided the restriction does not exceed 12 months and there are appropriate limitations, for example limited to a local geographical area. The Court of Appeal in two recent cases has given a warning that this cannot always be assumed. In one case concerning a post-termination restriction on a drain doctor franchise, the court ruled a 12-month restriction was unenforceable because there was a significant inequality of bargaining power and there was very little goodwill to protect. The franchise was terminated after just 18 months and there had not previously been a franchise in the area. In another case, a post-termination restriction was unenforceable because there was no interest to protect. The business seeking to enforce the restriction had not provided any know-how, and the contracted party was simply being commissioned to organise face-to-face marketing campaigns in the area using its existing local knowledge. In the recent case of Stitched v Force India Formula One team, Force India granted Stitched an exclusive trademark licence for Stitched to manufacture branded products, but then sold the business and did not transfer the Stitched contract, leaving Stitched with a worthless contract. Whilst the written contract did not prevent Force India from selling its business to a third party, the court agreed with Stitched that this should be implied into the contract. Now, the law allows a court to imply terms into a contract if it would lack commercial or practical coherence without it, and if the term is so obvious that it goes without saying. The new Subsidy Control Act 2022, the SCA, is expected to become fully applicable this autumn. The implementation of the SCA was agreed as part of the UK's exit from the EU and provides a framework for granting and controlling public subsidies. This was important to the EU as it was concerned UK businesses would otherwise have an unfair advantage over EU businesses that are subject to restrictions on public subsidies. The government has produced guidance on the new regime on its website. In a joint letter, the UK's data protection regulator, the Information Commissioner's Office, the ICO, and the UK's National Cyber Security Centre, the NCSC, reinforced the message that paying a ransom should not be viewed by an organisation as a reasonable step to take in order to protect data and will not result in a lower penalty by the ICO. The ICO has separately provided ransomware guidance on its website. The High Court has allowed Cadbury to register the trademark for the colour purple used on its chocolate bar wrappers. This decision creates an opportunity for other brands to follow Cadbury's lead, but it will not be easy as applicants will need to provide compelling evidence of acquired distinctiveness in the mind of the consumer. In 2004, Mr. Andrews lied about his experience and qualifications to secure a CEO role with a hospice. It was acknowledged that in the following 11 years he performed well in the role. The truth, however, caught up with him and he was dismissed and convicted of fraud, receiving a prison sentence. Following his conviction, the court sought a confiscation order of £643,000, being his full net earnings. The Supreme Court has ruled that he must pay back the difference between the higher earnings obtained through the fraud and the lower earnings that would have been obtained if there had been no fraud. We reported in March that the High Court had issued an injunction stopping Tesco from dismissing some of its warehouse operatives and re-engaging them on less beneficial terms that the warehouse operatives argued had been promised by Tesco as a lifelong commitment. The Court of Appeal has since overturned the High Court's decision, saying that the High Court misunderstood the commitments that had been made by Tesco, and in any event, an injunction was not justified. Tesco is now free to progress with their fire and rehire plans. Employers should, however, keep an eye on a new statutory code that the government has announced that will protect employees from the fire and rehire tactics. The Court of Appeal has ruled that an employer was liable to pay the level of sickness benefit payments detailed in the employee's offer letter, despite the employer subsequently changing insurers that did not provide the same level of cover. We recommend that employers specifically limit employees' benefits to the amount covered by insurance and ensure that the policy terms are available to employees. The government has published its response to the 2018 consultation on employment status, confirming that it will not proceed with any legislative reform. It has, however, published new guidance which includes an explanation of the differences between employees, workers and self-employed individuals, and explains how individuals can challenge their employment status. Superdry has been ordered to compensate a former employee £84,723 for age discrimination. The employee was a designer with over 30 years experience and had an outstanding record but was not offered promotion, whilst other less experienced designers had been promoted. Superdry was criticised by the tribunal for not providing any clear explanation about why the employee hadn't been promoted or what needed to be done to achieve this, and for failing to adequately address the risks of unconscious bias. In addition, the language used by senior staff had been inappropriate, particularly the employee's line manager, who had referred to the employee as being scatty. The tribunal commented that the term was loaded with subjectivity and verges on a term of abuse. A recent tribunal case has held that a belief that gender is a biological fact, not capable of being changed, is a protected belief, and provided it is expressed in a straightforward and objectively reasonable way, the worker will be protected from detrimental treatment. In this case, it was noted that the individual concerned, Ms. Forstater, had acted appropriately, including a modification of her conduct and agreeing to use colleagues' preferred pronouns. Accordingly, the tribunal found that her employer, having refused to renew her contract, had discriminated against her. Another tribunal has since given a very similar decision in a case brought by a barrister, Ms. Bailey, against her chambers, Garden Court Chambers. The Supreme Court has ruled that workers who only work part of the year, e.g. term time workers, are entitled to 5.6 weeks of holiday pay like employees that work all year round, even though this will result in part-year employees' holiday constituting a higher proportion of their annual pay when compared to that of full-time employees. In July, new legislation came into force to reduce the impact of the right to strike. The legislation removes the restriction on employers bringing in temporary workers to make up for the shortage resulting from staff taking part in industrial action. In addition, new legislation increases the maximum amount of damages that can be awarded against a union for any unlawful industrial action. Traditionally, competition authorities have focused on price fixing arrangements within the sale of goods and services. However, the Competition and Markets Authority has opened an investigation to BT, IMG, ITV and Sky UK to address concerns that they had colluded to fix the rates offered to freelance workers. That's it for this month. Thank you for tuning in. We've included links to all of the documents we referred to today in a written version of this bulletin, but please don't hesitate to reach out to me or any of my colleagues here at Radius Law for more information.